It's the legislature is called into session right now. Um, Clerk, do we have a quorum?
There is no quorum at the moment.
Okay, we will be in recess. If I can have the Sergeant at Arms please call the rest of the members in. Thank you very much. We'll be in recess until we can acquire a quorum. Thank you.
Would the clerk call roll and see if we have a quorum, or who's in the hall?
Present in the session hall is Senator Matt Rector, Senator Tina Muñoz Barnes, Senator Ben Panganinen, Senator Tamara, Senator Palacios, Senator Guthertz, Senator Blas, and yourself, Mr. Speaker. There is a quorum.
Thank you. We're on Bill 207. Senator Tomati, you're recognized.
Thank you, Mr. Speaker. I move that Bill 207-30, as substituted by the Committee on Utilities, Transportation, Public Works, and Veterans Affairs, be moved to the third reading, and I would like to discuss it, please.
That's as substituted?
As substituted, actually the bill itself was not substituted, but the attachment A, which is the rights of way manual, did have some amendments to it, and so we were advised that then I had to report the bill out as substituted.
All right. Any objection? There being none.
Mr. Speaker, we are projecting, of course, that there would be an increase in Guam's population over the next number of years, 20 years at least, from organic growth as well as from the growth because of the military buildup. And as a result of that growth, we would need to improve our highway infrastructure in order to be able to support the traffic activity that will be occurring on those roads. The plan for the roadway infrastructure improvement is based on the 2030 Guam Transportation Master Plan, which was transmitted to the legislature earlier during the summer. No action was taken on it, and so it lapsed into approval after I believe the 90-day period. The 2030 Master Plan, which is the basis for the roadway infrastructure improvements, did receive public hearings prior to its transmittal to the legislature. The funding for the projected roadway improvements on Guam over the next 20 years will be coming, is an anticipated approximately up to $3 billion in federal funds to make the necessary improvements to Guam's highway infrastructure. Unfortunately, the impact of the roadway infrastructure improvements will inevitably result in the acquisition, the need to acquire private property in order to be able to construct the necessary rights of way, which includes everything from the edge of the roadway out to the necessary buffer that's normally required as a standard. The right-of-way manual, which is an attachment to Bill 207, which is this manual here. This manual was provided to each of the senatorial offices. We also have a copy that's available electronically. What we've passed out is a...
Point of information,
yes.
Mr. Speaker.
Senator Reck, you're recognized.
The good mover of this amendment stated that we had to have a substitute bill because there's been changes in the right-of-way manual prior to or after this bill was introduced. And now my question is the right-of-way manual that we have in our office the same right-of-way manual that we're talking about adopting here?
Senator Atta?
If you just give me 1 minute, I'll check with my staff to see what they did send out.
Well, we'll go off the record for a while.
Staff has advised me that the,
Just a second, let's see, we're on. Are we, okay.
I've been advised by my staff that the copy of the right-of-way procedures manual that was made a part of the committee report is in fact the revised manual.
I understand, but I think Senator Rector's concern is we were all provided with a binder
Yes.
about a month and a half ago.
Yes?
And that, we were told, was the right-of-way manual.
At the beginning, and then, I'm sorry, go ahead.
For those who, unless they knew that the attachment was being substituted, would not have downloaded however many pages you had in the committee report to amend their binder and have a chance to read that. I mean, was that very clear that it was the bill and not it was the attachment and not the bill that was being substituted?
Well, I don't think it was spelled out explicitly, because even myself, I went through and I compared the two versions of the bill itself, and you would find in there that there was actually no change in the bill. It was in the attachment in the right-of-way manual itself. But maybe if it would allay the concerns of the members, I would just like to point out that the manual is really a compendium of existing local, federal statutes and rules of the Superior Court of Guam. And it is very clear in the manual that anything in this manual that conflicts with those laws and rules, that the laws and the rules will prevail.
I understand that, but I'm just trying to figure out how much, if it's supposed to be a compendium, why would there need to be a substitute if it was a compendium?
Because they added some sections.
Do you really think that we're going to be able to move through this?
Well, if I could, I think, the thrust of this manual is really to establish by law or an adoption of this compendium all the laws that exist that's related to land acquisition as may be needed in order to establish rights of way for Guam's highways. And I think that this flow chart that has been provided really kind of gives that pictorial diagram of what you would have in here. So if there's any questions as to what are all the requirements, for example, to have an appraisal done, it is in this compendium, it is in this manual, and it provides, for example, the specific statutes, local as well as federal, that would govern that process of getting appraisals. So if there's really any questions about the land acquisition process, it really would show up here on this flow chart. And basically what the flow chart shows is what sort of actions take place when land acquisition has to be initiated. There's that initial contact, for example, with the identified landowners.
Senator, how many pages are added?
Well, there was a section 8.5 which dealt with the issue of disposal of surplus real property. That was basically and then there's the issue of right-of-way property leases. That particular provision was added. Those were really the additions. There were some deletions, but there were some deletions.
For those senators who did not print out the committee report, how many pages will we need to print to be able to be up to date in our binder?
Well,
See, because everybody up here is asking, I have, this is all that shows in my committee, the committee report that's attached. And I'm trying to figure out, and I think legal counsel was trying to figure out how many pages were added, because we're still trying to figure out from this committee report what you're talking about as
okay, Mr. Speaker, then may I suggest, I'll go ahead and I'll have a copy of this run off for each senator, if that's the desire of the body.
The problem is we need to know what it is that you guys have added since you guys initially published.
I understand. And
we're trying to figure out, because, I mean, I carried that with me the last time I went to the States, and I reviewed some of it, and I need to know which pages you've replaced and what are the addenda.
Well, I guess the easiest way would be to run a copy of the table of contents, which then shows the marked up version. I have here the marked up version, which shows on the table of contents what was added and what was deleted, what sections were deleted.
Does that show, Senator, who prints out their copies of the committee report? Those of you, I see some of you with committee reports. No, I know, but not all of us get it. In your request, do you have?
No.
Can we move this to the side and get everybody whatever it is that you're going to do, and we'll come back to this at some other time, either later on today?
Okay, fine.
Thank you. Bill 209, Senator Guther's.
Thank you, Mr. Speaker, and good morning, colleagues. Bill 209 is an act to amend Section 13102A of Chapter 13 of Title 4, Guam Code Annotated, to expand its definition and to add a new sub-item 4 to Item A of Section 13102 to require all persons or public officials that have authority to enter into binding contracts on behalf of the government of Guam or any of its departments or agencies or autonomous entities and public corporations to comply with the Public Official Financial Disclosure Act of the government of Guam. Now, it is a known fact, Mr. Speaker and colleagues, that we soon will be seeing the military buildup take on a faster pace. There's going to be more interaction by representatives of our government of Guam with different entities, companies, contractors, providers of services, and there will be a host of contract agreements in the coming months and years. In correlation, the amount of funding that will be coming to Guam from the federal government and from private business and interests, and perhaps even some money from the Japanese government, will be in the hundreds of thousands and millions of dollars. This measure is a proactive approach because it will help to caution any thought or incentive by public officials to favor one company over another, as it holds those empowered with authorizing expenditures by our government to a higher standard. Existing law of the government of Guam already covers elected officials as well as appointed officials who require legislative concurrence. Bill 209-30 simply expands the number of individuals required to follow the island's public official financial disclosure law. Build-up funds will be used for almost every conceivable purpose on our island, and everything that can be imagined will be needed to build the marine facilities and other related military facilities in the community in order to accommodate 8,000 Marine troops and other service members from the other branches, such as the Air Force and the Army, that will be coming to Guam with their families. The government of Guam, on its part and for its part, will be investing a lot of its revenues and monies into additional infrastructure, including federal funds that will be made available to the island for this purpose. Bill 209 provides an extra layer of protection for the community as our government becomes more transparent by requiring more public officials who seem to have exclusive control over entering into contracts using federal monies made available to Guam to disclose potential conflicts, including those at autonomous agencies and public corporations who have authority to enter into binding agreements on behalf of the government of Guam. So with that, Mr. Speaker, I'd like to move Bill 209 down to the third reading file. Thank you.
Those who wish to speak on the bill, Senator Rector, you're recognized.
Thank you, Mr. Speaker. I rise in full support of this bill. You know, we are all responsible to the people's money. It's funny because I'll hear people talk and write, and they'll say things like the government spends this money, and the government spends that money, and they'll use this nefarious term like it's some sort of swear word, the government. But you know what? The government are the people, and the money is the people's money. And we need to hold everybody strictly accountable on how that money's spent, appropriated, or misspent, or misappropriated. And this bill does just that for these contracts. And I really appreciate the author of the bill and the co-author of the bill. And actually, if they would be so kind, I would love to be a co-sponsor of this bill. Thank you, Mr. Chair, Speaker.
Any objections? Any other senators wish to be heard on the bill? Senator Palacios, then Senator Arkin.
Thank you, Mr. Speaker. It's about time, Mr. Speaker, that we continue to extend the arm of this government in putting a check on government corruption. And this is one legislation that I can actually say that it is an anti-corruption legislation, and I love it. It promotes transparency. It increases, of course, deterrence against corruption. And a lot of times, we tend to think that only elected officials have power, but believe me, some of these boards to whom we have empowered to act in our behalf by granting them delegated authority play a major role in committing this government into a binding contract. And a lot of times with pains and I guess losses against the people of Guam. This, again, like I said, it continues to extend the arm of this government to be transparent and to put a check effectively on corrupt government officials. And those who are not yet corrupt, we have this statute that actually will increase the deterrence, make it much easier to identify who is corrupt and who is not. Thank you, Mr. Speaker.
Thank you, Senator Palacios. Senator Arkin.
Thank you very much, Mr. Speaker, and buenas and afade. I too would like to stand in support of this particular measure, Mr. Speaker. I think that any time that you have government representatives that would have the authority, not necessarily only be a signator to a contract, but would have the authority to be able to act at the behest of the people of Guam in using public resources, regardless as to where the funding is originating from, that those individuals need to have an open book policy in terms of providing their information and filing the appropriate reports with the respective entity. So I think it's very important in this case that these people understand that not only do they have and possess a tremendous responsibility in terms of acting on behalf of the people of Guam as it applies to different contracts, but they will be held accountable by virtue of filing their appropriate financial reports as would be required in this particular situation. Incidentally, Mr. Speaker, one thing that I don't know if it was mentioned a little earlier, but lack of filing your financial report could conceivably automatically lead to a misdemeanor. So this, I think, is not only an appropriate provision to provide in law, but that these individuals got to understand that, yes, you own a tremendous responsibility, and along with that, there's some transparency, personal transparency that also has to come along with that task and that responsibility and the position that you have and you hold acting on behalf of the people of Guam. So thank you very much. I stand in full support of this particular measure.
Senator Blas.
Thank you, Mr. Speaker. You know, Mr. Speaker, although I stand in full support of the intent of the bill, I sat back and I looked at the language that is being proffered, and I was thinking a little bit. First off, if you look at the word authority, you know, right now there's only 3 branches of government. There's only 3 people that have the authority to be able to do this. It's the delegation of the authority that has to be addressed. I don't know so much if this is superfluous, whether or not this is already just reinforcing an existing statute. Secondly, is if this is going to be extended to all persons or public officials, what of those classified employees? You know, right now, filing a financial disclosure form is not a requirement for a classified job. I'm concerned that we may be overstepping the bounds in as far as their rights as employees as well, and the protections that we give to these employees. So, although I agree with the intent, I recognize that yes, we want to be able to make sure that there's transparency in this. I'm concerned about whether or not, first off, the language is still too vague, or is it so restrictive or so broad that we're going to go into the bounds and infringe upon the privacy and right now the constitutional, in some cases, rights of some individuals. I don't know whether, for lack of a better term. So I'm going to sit and listen to a little bit more to some dialogue and some conversation. Again, although I appreciate and I support the intent of this, I don't know if this language is going to meet those requirements. It's actually going to be able to ensure that what we intend to do with this is actually going to be able to happen. Thank you.
Thank you very much. Senator Guthridge, do you wish to yield and clarify? Thanks for Senator Blas.
Let me say this. Thank you very much, Mr. Speaker. The current law already covers elected officials and appointed officials who are confirmed by the legislature. But there are numerous other individuals in this government that deal with letting out contracts in the millions and hundreds of thousands of dollars. And all of us have seen over the years some of the unfortunate abuses that have occurred and disappointments that have occurred because of the actions of some of these folks. And the intent of this law is to cover anyone who has control over letting out contracts and entering into binding agreements through the procurement process on behalf of this government. Examples are, and even though there's delegated authority to classified employees, maybe fiscal officers, that doesn't change the necessity of the need for transparency in the procurement process and in the entering into contracts for services or other activities. We most recently saw a situation that's still up in the air. We don't know what the outcome's going to be regarding committing this government to contractual arrangements with private companies without bids. And the intent of this bill is really to bring forth the realization that when you have the authority to sign your name and to award contracts and to procure services or goods for this government, you need to be squeaky clean. And one of the best ways to ensure that people involved adhere to the standard that everyone on Guam wants is to require the financial disclosure. Now, many of us here have been career employees in this government in the classified service, or the equivalent of the classified service is tenured academics. And there's no conflict here at all. Anyone in the public service, whether classified, unclassified, board or commission member, director, manager, senator, governor, we must stand for accountability and live our professional lives guided by accountability. And as our island matures and our government expands and the need for more services increases because of public need, there's going to be more transactions involving the procurement of goods and services and the letting out of contracts. And those involved in those processes must be transparent. And that's what this bill intends to achieve. It's a small beginning. Thank you very much, Mr.
Senator Guthridge, you do understand the question that Senator Blas was posing was the breadth of your bill could mean the certifying officers of some departments that
All of them.
all of GSA and a number of others. Are you proposing not only signing, but how about the panel that does the reviewing for letting of a contract?
Well, I personally don't object to that.
I understand, but
Yeah.
his concern is was that clear at the hearing, and was that taken into account, and how is that going to, how far down does this go? How wide does this go, and does everybody understand that this is happening?
Well, Mr. Speaker, I think at the hearing we discussed this. I believe that those who testified understood what the goal was. There was no objection to the intent. There was no objection to covering more individuals involved with any financial transactions that commit this government. And I think the Section 2, Item 4 says, and this is the expansion of the current law, and all persons or public officials that have consent authority to enter into binding contracts on behalf of the government of Guam or any of its departments, agencies, autonomous entities, and public corporations. So it's not the ministerial administrative work that goes in this process. It's those individuals that have consent authority that can approve this. And there are people in this government that can approve procurement contracts who are not elected officials or who are not directors. And that's who would be covered. Thank you.
And Mr. Speaker, and I appreciate and I recognize and I apologize, just to clarify my stance here. I recognize and I understand what the purpose is. I support the purpose. I support the intent. I'm just concerned that the language is first off superfluous, that it may not actually cover that to the extent that we want it covered, and that even at that, the extent of this may be so far that we're going to now require certain individuals in the classified service to submit financial disclosure forms, of which one is not a response or a requirement for their continued employment. It never was. Now, if we're going to do this, we may be discriminating against them. So it's not so much the intent of it. I recognize it and I support that. It is the way the language is written that I don't think that we're going to be able to achieve the goal. And so that's where my caution is at. Thank you.
Thank you. Senator Calvo, I'm sorry.
Yeah, thank you very much, Mr. Speaker. Mr. Speaker, again, I support the intent of the author of this particular bill in regards to transparency and ensuring that to the general public and to the community that those individuals that are tasked with fiduciary responsibilities, that either potential conflict of interest or their financial, their financial condition is made known to the public. That's what happens with a financial disclosure. But the way I read this, if the bill in its intent is to not cover those classified employees that were brought up earlier by the earlier speaker from Barragada, then those with consenting authority, are already obligated by law for a financial disclosure statement. And I talk about, again, whether it's a member of a board, elected official, or director. And this also includes the major executives for every branch of government, and that whether it's the governor or the speaker of the chief justice, they have to put out already a financial disclosure. So that's the case, then this legislation is not necessary because it is a redundancy. But with it, and again, with the vagueness of the language, and I recite the language, and all persons or public officials that have authority to enter into binding contracts on behalf of the government of Guam or any of its departments, agencies, autonomous entities, and public corporations. That general language, and if you take a look at Claudia Agfaji at GSA, or some of these other, in fact, many of these officials at GSA, if not all, you could, looking at this language, I don't see a difference between what their job description is and what is delineated in lines 6 through 8. It appears that what their job positions are. There is a harmony of definition with what is included within lines 6 through 8. And again, I understand for all of us here, folks, that have decided to run for elected office, or a director that is appointed through advice and consent. Again, when we take those appointments or we decide to run for office, we understand what that means, and again, of our responsibilities towards full transparency. But this sure appears to seem to me that we're talking about classified workers here. And classified workers, they've been hired to do a job, and certain responsibilities have been delegated to them, and that is their job description. But when you put out and you request the entire financial profile of an individual, you don't, that is not something that is within the job description or even what is asked for these individuals when they're applying for that job. And now, because of the situation they are and the job that they are associated and the delegation of authority that has been relegated to them, from what I see in this bill, they will now be obligated to have to furnish a financial disclosure. And again, I'm concerned. Maybe we need to have legislative legal counsel look into this. There may be some violations. It appears to me of federal law or maybe unconstitutional. Again, to the author of the bill, I respect her rationale, but based on the language, what I see here, and it's simple language. In fact, we have now a former sitting judge that's now sitting at the speakership, in the speaker's table. You look at this language, and it makes it very difficult for me to say that this language does not otherwise now bring in folks within the classified workforce. And if the intent was not, then again, why put it in? Because again, we already have where elected officials, the boards, senators, directors already have to put out a financial disclosure. So again, Mr. Speaker, until my concerns regarding the integrity of the privacy of our classified workers, unless I'm assuaged of some of my major concerns of this, I'm at this point not ready to move forward in my assent of the bill, even though I respect and agree with the spirit. So again, Mr. Speaker, I just would like to rise and again voice my major concerns in regards to where this bill may be heading. Thank you very much.
Can we take a short recess?
Mr. Speaker?
The legislature's back in session. The legislature's back in session.
Thank you, Mr. Speaker. First, I want to thank my colleagues for their valuable input in trying to make this work and to cover all the concerns that were brought forward. And if I may, Mr. Speaker, I'd like to proffer 3 short amendments to the Bill 209. The first amendment would be to replace the underlying language in the bill in line 6 to 8 with the following language. And all individuals who are given or delegated authority by an elected official or appointed official to have sole authority to enter into contracts for procurement. Exempt are classified employees who do administrative processing but do not have discretion on awards. That's the First Amendment.
Yeah, do you wish to explain your amendment?
Yes, this amendment basically makes it very clear that individuals who are given delegated authority by an elected or appointed official to have sole authority to enter into contracts for procurement would be required to file a financial disclosure statement. This would cover situations such as what we saw happen right before our very eyes a few weeks ago that still has not been resolved and has created many questions with respect to sole source procurement and things of that nature. I so move, Mr. Speaker.
Does anybody wish to speak on this First Amendment? Any Senator Rector?
Thank you, Mr. Speaker. Once again, we are moving forward to make a good piece of legislation better. And I rise in support of this amendment. And I would like to proffer an amendment to the amendment, if I might, to insert the words at the end of the first sentence where it says enter into contracts for procurement, and insert the words after that, or approve change orders.
Or approve change orders. No objection.
On
That makes sense.
Then I
Any
guess I don't
objection
even need
to
to
the
speak on the amendment.
Yeah, that's a good one. No objection.
That's it?
It's a great amendment.
all right, there being no objection.
Thank you.
On the
Main
Guthrie's on the main amendment.
Yes.
Right, Senator Blas wishes to speak.
Thank you, Mr. This is on the assumption we've divided the question? There's
Yes.
3 okay.
All right, on the First Amendment's been approved. Any objection to the First Amendment? Hearing none.
Thank you, Mr. Speaker. And for consistency's purposes, Amendment number 2 is to replace the subsection 4 with the following language. And all individuals who are given or delegated authority by an elected or appointed official to have sole authority to enter into procurements for contract, and if I may add, or approval of change orders, period, or approval of change orders, period. Exempted are classified employees who do administrative processing but do not have discretion on awards.
On this Second Amendment, who wishes to be heard? Any objection? On the Third Amendment.
Thank you, Mr. Speaker and colleagues. And the Third Amendment, and again, I want to thank my colleagues for their input on this. A new section is added to Chapter 5 of Title 5 GCA. Procurement authority may not be delegated to any individual who is not required to disclose information pursuant to 4 GCA Chapter 13, the Public Official Financial Disclosure Act.
Anybody wish to be heard on the amendment? Any objection to the amendment? Senator Blas.
Actually, if my question is actually, can be directed to legal counsel, if I can just have 30 seconds, I can run over to her.
All right, we'll take a short recess. We're back on,
Okay, give me 1 second.
we're back in session. Senator Blas.
Thank you, Mr. Speaker. Actually, I appreciate the opportunity to be able to consult with legal counsel, and my questions were basically answered. Thank you.
On the third amendment, do I hear an objection? Hearing no objection.
Thank you, Mr. Speaker. Mr. Speaker, are you ready to close?
Does anybody wish to speak on the bill before we have Senator? You may close, Senator.
Thank you, Mr. Speaker. I would like to thank my colleagues sincerely for their valuable input in helping to make this bill better. We all are here for the same purpose. We want to make sure we have accountable government and that our public service in all ranks, unclassified, classified, appointed, elected, etc., is really responsive to the best interests of the community. So I'd like to urge everyone at this point to please support Bill 209, and I thank you very much for your help. Thank you, Mr. Speaker.
There's a motion to place it in voting file. So ordered. Senator Ada, we'll go back to do I understand, Senator Ada, you wish to ask for us to resolve to the Committee of the Whole?
Well, if the body feels that that we need to resolve in the Committee of the Whole to answer what questions they may have, certainly the DPW's attorney is here, who's with the AG's office assigned to DPW, and the consultant is here. If I may, though, I did make the statement earlier that really the focus of discussion really should focus on this flow chart. And as the members go through that flow chart, if it is felt that there's a gap somewhere, then that's where we need to then go into more detailed discussion. For example, earlier, Senator Pangilinan did raise correctly the fact that the flow chart does not show the existing statute that requires legislative intervention when land condemnation is contemplated. And of course, as we were discussing that outside, the reason for that was that the right-of-way procedures manual was really intended to provide the procedure for acquiring land through a mutual agreement between the landowner and the government. It does provide on the last page of that flow chart what happens if in fact the negotiation is unsuccessful. And on that last page it shows going through the courts and the appeals and all that stuff. But what it does not show is the one block that shows that before we even go there, before you can even go to the court, it's got to come first to the legislature to get its approval that we can proceed forward in that particular direction. Now, another matter that I did point out earlier was that the manual is very clear that and there's a section 1.1.9, compliance with the law. And here's how it reads. Nothing in this right-of-way procedures manual shall be construed to diminish or supersede any provision of Guam or federal law or of the rules of the Superior Court of Guam. In the event of a conflict between this manual and any current Guam law, federal law, or rule of the Superior Court of Guam, then said laws or rules shall prevail. So in this case, it was very, the senator did point out, well then if this flow chart then is somewhat defective in that it does not show having to come to the legislature, then obviously adoption of this rules of manual, the right-of-way procedures manual does not obviate the existing statute that requires legislative approval prior to going into the land condemnation process. So, it's up to the body if they feel that we need to break into the Committee of the Whole. Otherwise, I think we should be able to handle it from here. The senator from Barrigada, also Senator Rector, did ask about the fact that this manual did go through some amendments from the time that it was initially introduced until the time that what we have now. And those amendments was actually, some of it was for formatting. For example, we'll find in the table of contents where we have a section 4.3, it just says reserved. That was actually an amendment it just changed the word deleted that was originally there to the word reserve and they did that to make section 4.3 simply a placeholder. But the more important part, the amendment, is that there was actually added 2 new sections. One section had to do with the disposal of real property. The second section had to do with the right-of-way property leases. And a third amendment that was made was they added some new forms that are used as we go through this process. For example, radon gas notification and disclosure of lead-based paint hazards warning, cash receipt form, lease aging report. So those were really the changes. And so, again, this right-of-way process is not changing any Guam law. All it's doing is it's a compendium of existing law and rules of the court into one manual. And if we wanted to know then how to acquire property for purposes of getting rights of way for our land, or for that matter for Guam Power Authority, then this is the place to go through. Now somebody asked a very good question. So, if this is just a compendium, then why do we need
I'm sorry,
to
Mr.
adopt it
Speaker,
by
just
law?
a point of information. Only because he's on this train of thought. If I may, Senator Ada. There was a statement that it would not impact any law or any rules, but there's a provision here on page 3, subsection B, that says notwithstanding any other provision of law, rule, regulation, or executive order. So I would think that upon the adoption of this rights-of-way manual, that this rights-of-way provisions would exceed or override any existing provision. So I just wanted that statement of clarification, and I know it's not the intent of the sponsor of the legislation to move in that direction, only because he just stated. So I wanted that clarification, please. And Mr. Speaker, if I can ask the good sponsor of the legislation if I can get some assurances that his statements are absolutely correct. Thank you.
Mr. Speaker, my response to that is really I have to rely on that section 1.1.9, which again reads with the compliance of law, and says if there's anything in this manual, if there's language in here that says notwithstanding anything else, here's what we want to do. If it's in conflict with law, then that notwithstanding language does not obviate existing law. And that's what I put my reliance on, that existing law. For example, the law that says the legislature has to approve any land condemnation actions before it goes to the courts, that remains, even though the flow chart does not show that.
Please.
I'm sorry.
There was no new one. They just sent to us addenda. There was a cover memo and says, please put this in chapter 1 or in a couple of chapters that they added into it.
Can I ask for just a 1 minute?
We'll take a short recess.
Okay, the legislature is back in session. I recognize Senator Ada on Bill number 207.
Yes, Madam Speaker, I'll ask that we suspend discussion on Bill 207, and we'll go ahead with the rest of the bills on the agenda. However, I'd like to ask that,
Well, let's take care of that first motion.
okay,
Motion then to suspend, no objection? So ordered.
then I would like to ask that before we recess at the end of the day, that I be allowed to make the motion to move, to go into the committee of the whole. This is a major bill, and we should have the subject matter experts available to really answer questions that the members might have. So that then if we go into the committee of the whole, we'll recess until Monday to begin those discussions.
Do the members understand the motion? Senator Agan, you recognize on the motion?
Just a request, thank you, Madam Speaker. Because if we had gone into committee in the whole this morning, apparently the consultants would have been here, but not representatives of the government of Guam. Can I also request consideration by the chair if in fact government of Guam, the director or the representatives also be present for the committee in the whole Monday? Just a suggestion. Thank you, Madam.
Madam Speaker, for sure, the director of DPW will be here. The assistant AG that's assigned to the Department of Public Works will be here. And the consultant who assisted in developing the procedures manual will also be here.
Okay,
And other persons as
we need to
necessary.
clarify here some things. One is your motion then is to be allowed before the end of the day today to make that motion to go into committee of the whole Monday morning.
That's correct.
Okay, so it's not that you're making that motion right now.
Well,
I need to make it clear for those who are listening and what
well,
they're going to
if
be
it's
voting for.
appropriate to make the motion now, it probably be a lot cleaner if we do it at the end, and then that way as the chairman, I can call the committee to order and then recess at that point until Monday. However, procedurally, whatever works, Madam Speaker.
Okay, so please remind me then before the end of the day then to make that.
Procedurally, could I go ahead and call for that and then just immediately, oh no, can't.
No.
Because once we go in.
It would be best to do it at the end of the day then.
That's right, okay.
So there are no objections then, senators? Are there any objections to allow, I'm going to explain. There is a motion then that the senator is requesting is to before the end of the day today, that he be allowed to make the motion to have us go into committee of the whole Monday morning.
For purposes of discussing Bill 207.
For purposes of discussing Bill number 207.
So, point of information, Madam Speaker. So, the motion is to allow him to make a motion?
Yes, at the end of the day, not right now.
No, the motion to suspend discussion, if I'm correct,
That
Madam
was the
Speaker,
first one, and that
has
was
already
approved.
passed.
Yes.
Now we're discussing a motion to allow him to make a motion.
To come back at the end of the day to go in the committee of the whole so that we can, the first thing on Monday, that would be the first order of business.
Well, actually, there's several things that could actually happen. Is that towards the end of the day, when we're done, is that Senator Ada, you can request to make a motion. Then you don't. I guess what I'm trying to say is you don't need to do that now for you to be allowed, because that can be done anytime, or it can be done first thing Monday morning. But it doesn't have to be now. Then and the
Whichever
Senator
works.
Rector has a point.
The
in
bottom
a sense
line
that,
is to go into the committee of the whole.
and I would, you'll be able to do that then later on this afternoon.
Okay, thank you.
Yes.
I'll make a motion, then if I might, Madam Speaker.
One moment, please. We had a point of.
Just a point of order,
Point of order.
Madam Speaker. According to our rules, Senator Ada, it would be proper for him to make a motion to a time certain. So he could make a motion time certain that says at 4:10 this afternoon. We will resolve it to committee whole and recess until 9 tomorrow. I think that would be proper.
Yes, and you can make that this afternoon. Yes.
So, Madam Speaker, if it's appropriate, the motion that was just articulated. Okay, not a problem. So I just,
No, the motion that, wait, one moment, please. The motion that I'm going to accept is, because we're right in the middle of the discussion of 207, will be the motion to dispense it, and that was already passed without any objection.
yes.
But we are still on the second reading, second reading file. So really, in essence, that should end there, and we should move on to the other bills. Later on this afternoon, then Senator Ada can request to go back to motions.
All right.
And then that's when the motion will be made with a time certain of the discussion of Bill 207, whether it's the committee of the whole or whatever.
All right.
Okay, so that motion, Senator Ada, then was accepted without objection, then to dispense discussion. So, and since we're in the second reading, we'll continue with the next bill, which is then Bill 210. And I'd like to recognize the author, which is Senator Taitagui. Is she in the hall? Until she returns, then I'm going to go on to the next bill, 214, which is Senator Palacios. Oh, she's here. I'm sorry. Thank you then, Senator Taitagui. On Bill 210.
Thank you, Madam Speaker. I move that Bill 10 be placed on the third reading file, and I would like to speak on the bill.
Please proceed then.
Madam Speaker, the intent of this bill is just to provide the means of covering the costs of issuing the Guam identification cards, to give this the fee that is charged to who's currently doing this right now, issuing them, and that is the Department of Rev and Tax. The history on this was that at one time, it was about a year ago, it was transferred from the police department to Rev and Tax through a memorandum of understanding. And in that memorandum of understanding, it was stated that the Guam Police Department would provide a couple of individuals from their department to issue these ID cards. That lasted for about, I think, 3 weeks. And from that time, no representative from the police department was there to issue this, and the burden was placed upon Department of Rev and Tax to do this. And this bill would simply give the fee from that department to Rev and Tax that is being charged, but at a minimum amount, Madam Speaker, not the full amount, but the amount appropriated is equal to higher of 1/3 of the amount of the fee collected, or $10 per applicant. Now, it costs about $25 to purchase your identification card, and we're only asking that Rev and Tax, at this point, if anybody would like to make an amendment to for the other, a different amount, I'm welcome to that as well. And this is basically just simply put that those who are doing the job should be paid for this. Thank you, Madam Speaker.
Thank you very much, Senator Taitagui. On the motion, Senator Palacios, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I rise in support of this bill. Following a public hearing, there was a meeting, of course, with relevant taxation and GPD, and of course the author in my office. And what we I seem to agree at that time is that as much as we would like to make this effective and completely turn over the funds to Department of Revenue and Tax, which they are entitled to at this point, they're the ones that are issuing the citation. But because the current Budget Act actually considered the projected revenue from the ID card as part of that appropriation, in fact, and so it is also factored in, and to not continue to allow that to be there might, I guess, offset the ultimate budget need for the Guam Police Department. So 1/3 of $25 or $10, I think, is not too much of an adjustment downward from GPD. There is an agreement at that time that eventually, because there are two laws actually that provide, rather the original law that authorized the Guam Police Department to issue ID card is still active. Now there's another subsequent statute that also grant the Department of Revenue and Taxation to issue Guam ID. I don't know whether by that meaning some kind of like the driver's license. At any rate, it was through the misinterpretation by GPD thinking that now the Department of Revenue and Taxation will issue that ID, and they're doing it under that statute. So eventually what we're going to see is that the issuing of the Guam ID would be completely absorbed by the Department of Revenue and Taxation and not by GPD. And so the amendment to do that, we have to amend that law, I think, during this term to correct that. In the meantime, the 1/3 or the $10 from what is being collected right now by GPD revolving fund will now go to the Department of Revenue and Taxation, because now it is the Department of Revenue and Taxation that is the only agency that issued the Guam ID, not GPD. So that is I think, the compromise at that point. I think, again, considering that GPD already has this in its budget, expecting the revenue from the ID card. So now it will be reduced by 1/3 going forward. So I support this bill, again, with the understanding that there will be another standalone bill to completely relieve GPD of the authority to issue Guam ID and completely turn over the collection of the revenue to the Department of Revenue and Taxation. And I support this bill. Thank you, Madam Speaker.
Thank you very much, Senator Palacios. On the motion, I have Senator Uggan.
Thank you very much, Madam Speaker. I certainly stand in support of this particular measure. I think that any time that you have an agency administering a particular program, rightfully so, the resources should be able to go to that particular agency. I just have a couple of questions, Madam Speaker. If the sponsor of this particular legislation can yield, I would appreciate getting some clarification.
Senator, do you yield?
Yes.
Please ask your question.
Thank you very much, Madam Speaker, and thank you, Senator T. In terms of the legislation, I think that the good senator, the previous speaker, had shared with us that in fact there may be a code or in the law that Revenue Tax now has assumed the responsibility of providing for the Guam identification card. Is that the case?
There is no code right now. There's a memorandum of understanding between the agencies.
Okay, then my follow-up question would be, because I know you mentioned that, I'm sorry for interjecting, but you mentioned that a little earlier, then my follow-up question is GPD tasked by mandate, by statute, to be able to provide the Guam identification card?
There is current law, if I'm not mistaken, that says that it's the person who issues the ID card will be the one who receives the fees from it.
No, but
particularly at GPD, yes.
Yes. So I think that really, Madam Speaker, has to be clarified in terms of at least allowing, if it's a decision of the body and the sponsor of this legislation to continue to allow the Revenue Tax to provide the Guam identification cards, then by all means, we need to go into the statute and make that appropriate amendment. That's one suggestion. The other one is, I'm questioning why would we want to only allocate 1/3 of the resources if it's $25 at a cost or payment, fees collected for each identification card. Why would we only want to allocate 1/3 to the program administrator of that card?
Well, the reason why is that, of course, the money that's received from these fees goes directly to the police fund, which is these police service fund. And, completely taking it as a whole will probably cause some loss of revenue for GPD, which they use this fund for. So instead of just, hitting them hard one time, we thought that it would be done gradually and only allow this amount to be proffered. Now, the cost in putting this together, we found that this amount was sufficient in providing one individual from Rev and Tax to continue to issue out the ID cards.
Thank you, and thank you very much, Senator T, for your explanation. I just think that I understand that GPD is always in need of additional resources, and I believe the good chair of finance had ensured that in the budget for fiscal year 10, that as much resources was directed towards that particular agency so that it would cover the operational requirements in fiscal year 2010. But in following up the statement that was made, Madam Speaker, about in this particular case, $10 would be a sufficient 1/3 of the cost or the fees generated. This would be codified. So in essence, in fiscal year 2012, fiscal year 2015, all of these resources of the fee assessed of $25, only $10 will be remitted to the agency that is providing and administering the program and creating the cards for our people. And I think that if in fact is the intention of the sponsor to eventually allow for the transition of these resources, which I'm under the impression is cost recovery. It costs possibly $25 per Guam identification card, and rightfully so. If Reverend Tax is administering that program and providing all of the needed documents and whatnot, and laminated identification cards, then it really should eventually transition over to Reverend Tax so that they can have those resources as the administering entity. So, but although I do share her concerns about trying to continue to allow some of these resources to remain within GPD, I think that having served in this body for many, many years, Guam Police Department is perhaps one of the entities that continues to get reinforced funding almost every fiscal year to support their operations. So in that particular light, just a couple of issues again, Madam Speaker. One is if
Are there questions? Do you still need the...
No, thank you, Senator T. That's why I said thank you, Senator T, and I thought she was going to sit down. But in this particular case, just to reiterate, just a couple of issues. Obviously, if it's by statute that the Guam identification card be provided by GPD, and there's an MOU to Reverend Tax, and that's a wonderful arrangement at this point in time, then we really need to go into the statute and make the appropriate amendment. And then perhaps in line with the statements of the sponsor, eventually transition really the cost recovery or the fees that are collected over to the appropriate administering agency, and it only makes sense in terms of trying to move in that direction. Thank you very much, Madam Speaker, and I stand in support of this legislation.
Please, Senator Palacios, state your point of clarification. No such thing but point. Go ahead.
Thank you, Madam Speaker. Madam Speaker, again, we had a very elaborate, extensive markup or a meeting in my office. And yes, there is, subsequent to this and maybe very soon, a standalone bill that eventually would completely place the mandate, or rather the responsibility for issuing the Guam ID card to the Department of Revenue and Taxation. But why didn't we do that in the markup in this bill is that, first of all, of course, you have to amend the police service funds, because right now, that's where the money goes. You have to say that it's not going to go there, it's going to go to some other account. And also, that the Guam Police Department already factored in, and in fact, this legislature considered the revenue from the police ID card, I think about $8,000, $10,000 per year, factored into that. But with the passage of this, it will take out 1/3 of that, or $10 of every $25, which is greater. I think $10 is greater going forward. which is, I guess, 9 more months remaining, or 10 more months remaining of this fiscal year. So that already would be an adverse effect on GPD. Now, there are 2 laws right now, actually. The 1954 law that when established, the Guam Police Department provides that the police department has the authority to issue, it says ID card. Now, subsequent statute also says that the Department of Revenue and Taxation may issue ID card, and that's why at that time we were debating whether, is that referring to the some kind of ID card like the handicap ID card, or for example, the disabled ID card, or the driver's license, which can be likened as an ID card. Now, GPD, when they found that statute, they say, well, you have to do that. Not thinking that, and then thinking that perhaps maybe they can still keep the fee. But for the research, finally they found that no, they are authorized to do that, which is revenue tax, but that does not relieve GPD from its mandate to be able also to use that. So we have to reconcile that with the author on a standalone view and correct that, and just have Parks Revenue and Taxation be the authority to issue Guam ID card. In fact, they receive federal funds to do what do they call that? The Safe ID or Real ID? And the only concern with GPD is that when they were issuing citation, the ID card, they take fingerprints. And then when they run these fingerprints, a few times, the fingerprint shows 3 names. And they say, well, we issue already ID card. Now you're applying for a different Guam ID card or a different name. And the concern is that at this point, Revenue and Tax does not have that capability, but I think that, again, there's a tentative agreement that they can take the fingerprint and then give it to GPD for input. Anyway, all of these things will be, of course, will be reconciled, I guess, within the next 12 months. But eventually, the Department of Revenue and Taxation will be able to do all of that, including making sure that they're not issuing 2 or 3 different Guam ID cards to the same person. They will have that safeguards. And that is why we didn't take the whole entire amount, because of the GPD is already relying on it.
Thank you very much for that long clarification. Okay, so on the motion then, are there any other speakers? Senator Rector.
Thank you, Madam Speaker. Boy, for such a short bill, it certainly gets rather complicated, doesn't it? When I just looked at the committee report, in listening to all the discussion of my colleagues, it seems like this is a problem that needs a more comprehensive solution, especially when in the committee report, it says that Chief Suba, it doesn't favor this bill. It also says that the officer in charge of the department at GPD, Captain Charfris, doesn't favor the bill. And for all the reasons stated by the previous speaker, obviously there needs to be changes. And so I'm afraid when the people that this is supposedly going to benefit, and the department that this is supposedly going to benefit, come out and say that they don't think it's going to benefit them at all, I'm afraid that I really couldn't support it. And I would suggest we send this back to committee and come up with a comprehensive bill that solves the real problems that have been raised. Thank you, Madam Speaker.
Thank you. Senator Rector. Senator Blas, you're recognized on the motion.
Thank you, Madam Speaker. Madam Speaker, I rise in support of this bill. This bill basically just attempts, what this is a start, and recognizing it's a start. To ensure that as the government continues to provide these ID cards, that there's a means to replenish those supplies, that material that is utilized to create these ID cards, as well as to pay for some of the costs, the administrative costs associated with this. I recognize and I agree with a good senator from Salampago that in subsequent legislation there and future discussions, there has to be that discussion as to where the allocations go. But as it was talked about earlier, it's already a $25 charge. It's only asking for 10. First off, I can understand why any agency, when you decide you're going to take money away from them, they would oppose the thing. But at the same time, I think that this agency should be thankful that now, although there was this whole discussion about who's responsible for issuing these ID cards, now as a result of what has happened over the last couple of years, the Department of Revenue and Taxation has taken over that responsibility. GPD doesn't have to worry about it anymore. Yet they still, in this bill, they're still going to get some money for it. I can understand where their objection is at, because we're taking some money away. But at the same time, if we don't do this, we don't resupply, we don't provide revenue and tax with the monetary means to be able to continue to provide identification cards. If they can't issue identification cards, no $25 is going to be remitted. If there's no $25 remitted, guess what? GPD is not going to get a cent. So, in order to the expense of doing business, they're going to get their $15 right now. This is only asking that revenue and tax gets $10 of that. There's going to be a discussion later on as to whether or not we can reapportion that. But that's a discussion for later on. Today is the discussion on making sure that the entity that is now responsible for issuing these cards has the financial means to be able to continue to do that. So I support this bill. Thank you very much.
Thank you very much, Senator Blas. On the main motion, are there any other speakers? Senator Taitigui to close, or motion to send down?
Thank you, Madam Speaker. I'd like to thank those who stood in support of this bill, and recognizing that when somebody does a job, that they should be paid for it, especially if it's coming out of their own pocket, and in which their agency is lacking funding to continue their own operations, let alone someone else's operations. But I do understand the concerns of individuals who are opposed to this, that there should be some kind of consideration of the department's dislike into this bill. And just a point of information with regards to that, during the markup meeting, GPD never showed up. So if they were so concerned about this, then they would at least, we sent messages, we put it in email that we were having a markup meeting with regards to this, and they never showed up. But in all, with another bill that may be coming up in order to transfer this through statute, we have to also remember that what is being implemented now in the federal government. The federal government has issued out what's called the Real ID card. And this the Federal ID Act says that whoever issues the driver's license will be the ones to issue out the Real ID. Now, the Real ID, it's complicated, but basically in a whole, what it does is allows individuals who do not carry a passport to travel from one state to another, or even through the territories, with this Real ID card. And that is going to be federally funded, and already Rev and Tax has started this, the implementing of the grant to receive the grant for the Real ID card, preparing themselves through equipment and technology to provide this service, which will soon happen. So with that, I ask again those who are not in support of this to consider it, because of what will happen in the future. And I thank everyone who spoke on behalf of this, and also like to thank my co-sponsor, Senator Palacios, who was very good at giving out information.
Hey, Your second co-sponsor, Senator Pangilinan.
No, 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 no. As always, you save the best for last. I'd like to thank my co-sponsor, Senator Pangilinan, who both him and I, when we heard during budget hearing, was listening to some of this, and we looked at each other and said, what? They're not getting compensated for something they're doing? And he recognizes that as well as I do, and I'd like to thank my co-sponsor to this bill, Senator Pangilinan, and also like to add as co-sponsor, Senator Palacios.
So on the motion then to make Senator Palacios third co-sponsor without any objection, so ordered. And on the motion then to send Bill 210 down to the third reading file without any objections, right? There is one objection, so please raise your hand then to, you said you objected. Oh, you. Okay, so there are no objections then, so it's down to the third reading file. Ordered. Bill number 214, I'd like to recognize the author. It will be Senator Palacios.
Thank you, Madam Speaker. Madam Speaker, Bill 214 proposes to establish a quorum, a minimum number of members for quorum for the POST, Peace Officer Standards and Training Commission. And this commission is a 17-member commission, 14 of whom are voting. And there's actually no provision, I made the research, there's no provision as to what is the majority, so they rely on the, I guess, the general standard that 8 out of 14 is the majority. Since the establishment of this commission more than 2 years ago, I think they met only 3 times as an official meeting. And it's been very difficult for the commission to attain 8, usually 6, 7, 5. And it was requested of me to look at this and perhaps establish a quorum, and because of their experience, they say that, and I say they, I mean Dr. Magnich and Phil Tadinko. Attorney Tadinko, by the way, is the interim chair of the commission, and Dr. Magnich is the interim executive director. And so they're operating whenever they were to meet and they don't have a quorum, they just went ahead and conduct some informal meeting and so forth. From time to time, the executive director, of course, issued an interim amendment or interim standard or whatever that they may call it. The fact of the matter is they are not functioning fully as they would like to do. And so by establishing a minimum number of 5 as a quorum, they still retain a 14-member commission. There was an original request to reduce the number, but I think that's more complicated. Why don't we just establish a quorum limit or a minimum, and then from there, everybody can still come. All of the 14 can still come, but at least the commission will be allowed then to proceed and do official activities, official action, and continue to perform. See, the purpose actually of the commission is to establish rules and regulations and set minimum standards to serve as a basis, of course, for recruitment and training for law enforcement officers. And that is actually, and then they will be the one to be certifying as to training, issue certificates, and so forth. But right now they are not fully functional because they are not able to actually come together and do a real good work with respect to what they are mandated to do. And that is the only reason for this bill, is to establish a quorum, making it 5 to be a quorum, so that they can go on with their business. And I ask my colleagues to look at this, and if there's any concern, we can, I guess, refine this. Thank you very much, Madam Speaker. And of course, I move that this be placed on the third reading file for purpose of continuing discussion. Thank you.
Thank you very much, Senator Palacios. On the main motion, Senator Pangilinan, then Guthertz.
Thank you very much, Madam Speaker. Madam Speaker, I guess this is one of those kind of legislation that it would be probably similar to the legislature being able to stop the clock and extend the day beyond 24 hours. I don't necessarily have any objection to maybe, getting the commission moving forward. But I just can't, I don't know, something in my gut says, and it's a big gut, so there's a lot of room for error probably, but it just, something in my gut just says that, when you don't have something that functions, and it can't function in the structure, then to change, the solution will be to change the structure. So in this case, if 5 is a quorum in a 17-member commission, 14 voting, now 5 is a quorum, and then the concurrence of a majority of the members present, let's say only 5 come, now you can, in a 14-member commission, carry a motion and change something with just 3 votes. I mean, the math just can't seem to come together for me. The policy can't seem to come together. Why don't we just change the membership of the post commission, or just change the voting members and just say only 5 members shall be voting? Why allow somebody to come in and, so that this allows for all sorts of games to be played, I think. That we'll only call these people for the meeting, or we'll make sure we have a meeting in this, and we'll make sure we only have 5 if we want to do this, because these other people may not agree with it. I really have a problem with redefining quorum rather than redefining the structure. I would prefer that we just say, these are the only members, everybody gets to come and put their input in, but these are the only members that have authority, rather than saying only these members are needed to conduct a meeting and conduct business and move things forward, and leave all these others out there hanging that can come as they wish. And when they don't like something, they'll come and defeat it, and then when nothing's happening, there's no sense of responsibility that's going to be built. We already know there's no sense of responsibility for the members because they're not showing up. So maybe we should reconstitute the structure rather than reconstitute the quorum, and keep this idea that, majority votes, majority rules, rather than saying the new majority in 14 is 5. It just can't be. Of course, the legislature can make it be. But, again, to me, I understand that why we need to do this. I just don't understand why we're doing it in this way. And so, not being familiar with who sits on there at this time off the top of my head, and why only 5 people would come. Then let's just change it and just make those 5 people who come be the voting members, and it takes 3 votes, and everybody else knows that that's the way it is, rather than some, the 6th guy or the 7th guy or the 8th guy or the 9th guy or the 10th guy or the 11th guy or the 13th guy or the 14th guy come whenever they wish and upset what the others want to do, who are consistently there trying to advance the commission. So again, I would prefer that, my preference would be that we reconstitute the commission, redefine who gets to vote, rather than redefine what a majority is, and allowing 3 people, when we thought originally that we needed 14 people there to move forward the policy for this program, that we thought in the beginning it's important to get these 14 minds there and have their input to advance and make changes in the development of policy and the implementation. Now we're just saying they're still important, but they don't count anymore. Only 5 will count and show up. Well, let's pick the best 5 and say only those guys get to vote. And now we can then go back to this idea that a majority is 1/2 of +1 of the whole, rather than it's now a majority is one third, almost one third of a whole. It just, and then only 3 can carry a vote out of 14. It's just, again, the structure, the math doesn't settle well with me, and the preferred solution to this would be to reconstitute or redefine the voting authorities of that. And I can't, I can't support this redefining of it in this manner. I support the attempt to put in a system and a process there that will advance the work of the commission, but not in this manner. And, the only other appointment again, the way I would do it would be to redefine who gets to sit on as a voting member, and then say a majority of that, rather than keeping voting rights intact, but changing it, or defining that all the alternates that come, if there's no quorum, if there's no voting member, if they're the 14th guy, then the 15th guy get to vote, and the 16th guy get to vote, and the 17th guy get to vote, and give those guys voting authority who may have an interest and come. That would be another way of handling it. Much like we have GVB, you have alternate members, and when those alternate members come and the voting members don't come, they become automatically voting members. So maybe that's one way of trying to find that additional 3 or 4 that can come and move the process and the progress of the commission forward.
Thank you very much, Senator Pangilinan. On the main motion, are there, Senator Guthridge, you are recognized. Senators, do you want to have a recess or something?
I think Senator Palacios wants to speak first. That's fine. Point of order, Madam Speaker.
But, he'll be able to close yet, yes. Oh, okay. As Senator, then Palacios, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I agree with the last speaker. In fact, that was the original request from my office. But when we sat down and this is a point of information that I'm providing, is that who are we going to remove? I mean, you have their appointment from the Mayor's Council as a member, someone from the GCC, someone from UOG, which in my opinion, having been in law enforcement, probably is not as much relevant. I mean, whatever that we package as a training package, you have to be able to teach it, because we determine what the police officers need. You don't. Then you provide the training as we formulate it. That's my thinking of training. It is not for them to decide what the police officers must be taught, because they are not professional law enforcement officers. At any rate, the original request was to bring it down to 7 and just confine it to the main law enforcement agencies. We have one currently, as it is right now, because law enforcement, the parks rangers, they have 1. Customs and Quarantine have 1. The conservation officers have 1. Port Authority has 1. And that's why we got up to 14. And then you have the GCC and the UOG. So I agree with that we should actually cut it down to 7. The problem here is we're going to have to decide who to remove. And a lot of times people that do not attend this, for some reason when you decide to remove them because they're not attending, then all of a sudden, now it becomes an issue that's not necessarily related to this. But I will then withdraw this or pass it. I pass it on file, and then I can introduce another bill to do exactly that.
So pass on 5 then.
So I move that Bill 214 be passed on file, be set aside.
Okay. On the motion then to pass on file Bill number 214, are there any objections?
Thank you, Madam
Thank you very
Speaker.
much, Senator Palacios. We're going to take a lunch break. We will be in recess until 2 o'clock this afternoon. who are here and whether we have a quorum.
Maybe you should say who's not here.
You want to try that? Well,
Present in the session hall are Senator Ada, Senator Palacios, Senator Rector, Senator Cruz, Senator Blas, and yourself, Madam Speaker. No quorum.
thank you very much.
Who's not here? Noticeably absent.
I'm sending out all the cell phone violations for the violators out there. Make sure you pay up.
So you can get a present for being present.
Can you announce the cell phone violators?
Yeah, okay, I have it written here.
Okay, I'll take care of it.
Hey, somebody step. Hey, my cell phone never goes off.
Vice Speaker Cruz, you're recognized on Bill 220.
Thank you very much, Madam Speaker. I move that Bill 220 be placed in the third reading file for discussion, and I'd ask for a few minutes to explain the bill.
Please continue then.
Thank you very much, Madam Speaker. Madam Speaker, on the 19th of August, I introduced Bill 220 to try to address a problem that we had been watching over the last year grow exponentially, it seems. And that problem has been procurement problems and procurement appeals. We are now in the midst of at least several months, maybe years of, hopefully not years, but I mean, seemingly it's going to be years of protest over the building of JFK because of problems of the way that they conducted their procurement and the bidding process. And so I introduced the bill to try to include the Attorney General in procurement oversight of any procurement over $200,000. Almost immediately, and I've provided to all the members a series of letters that I've received from the Attorney General 2 days after, starting on the 21st of August, from the Attorney General, stating that she supported the idea of being included in the in this process, and but making suggestions that we might want to increase the amount from 200 to 500,000. And so at this time, Madam Speaker, I'd like to move an amendment that's attached to everything that's on your desk. It's an amendment to 5150. Does everybody have a copy of that? It's in very tiny print. It should be like the...
Okay. Is it the one that, is it the one that says duties?
Yes, duties of the Attorney General.
Okay, does everybody have a copy? Okay.
And the amendment is simple, that whenever the Chief Procurement Officer, the Director of Public Works, or the head of any purchasing agency conducts any solicitation or procurement which is estimated to result in an award of $500,000 or more, the Attorney General shall mandatorily act as legal advisor during all phases of the solicitation or procurement process. As you can see from the subsequent correspondence that I've received from the Attorney General on the 15th of September and the 26th of October, we can see how much time is being spent and how much attorney time is being spent by the Attorney General's office. Currently, the Attorney General does participate in approving contracts when it's all done, and they do have a checklist of things that needs to be done. Sometimes she has to send, the Attorney General's office has to send back the request for a contract because the attorney in charge of procurement has come to realize that that the department or the agency has neglected to do certain things in the checklist, doesn't provide certain proof that certain things were done, and it just causes all kinds of problems. Madam Speaker, the reason why I'm most concerned about this is because with some of these large contracts, it affects the most vulnerable in our community. The problem that we have right now with JFK affects students who are going to graduate from a high school and might never have attended or been on the Tumon campus by the time that they graduate. And I think that, for lack of a better word, is criminal. That the class of 2012 will graduate without ever having to had one day of class at the Tumon facility, because this process is going to be in protest for a considerable amount of time. We're currently under protest for the food services at the Department of Education, which almost did result in the schools being closed for a couple of days because there was no way of feeding the students for a couple of days. The other vulnerable individuals in the community that are suffering Department of Mental Health and Substance Abuse, because of their failure to comply with procurement processes and their RFPs, There's an issue as to whether or not Catholic Social Services, Laddie, and all the vendors associated with the Department of Mental Health and Substance Abuse, DISID, and were properly done. And so consequently, some Catholic Social Services and some others, Laddie, are actually taking care of people with mental health problems and disability problems, because they're not going to put them out on the street just because the process isn't completed. But what's going to happen is that these agencies are not going to be able to get paid. I mean, we had this problem several years ago with Sanctuary, where they weren't going to discontinue their services to the children that they take care of, and they continued to work on the good faith of a contract that was supposedly going to be coming down from DYA. And as it turns out, we had to, just recently, passed legislation to allow them to be paid in spite of the fact that they had no contract during a whole period. I think it was 2005. There are all of these issues. I mean, just this last week, or day before yesterday, with the closing of Finnegadson and the whole procurement problem that we have at Department of Education. It is imperative that we include an Attorney General. And I know in her letter of October 26, she talks about the need that she might need to have additional money, but at least for right now in this legislation, it's just including her including the office in the process. We'll deal with money later, but we have to start getting them involved in the process so that we don't have all of these problems cropping up later, resulting in procurement appeals, procurement protest, and other issues that affect children. I know that some people are concerned about the big projects for roads and other things. I mean, it's not that I'm not concerned about those, but I think those big boys are going to be able to take care of themselves. But my concern is that when the children don't have food, the children don't have schools, the ones that are disabled and suffering from mental disabilities have the possibility of being put out on the street because contracts aren't being let properly, and the process is going to be challenged. I really do have concerns about that, and I want to thank the Attorney General's office and the chairman for conducting the hearing as expeditiously as he did, and their suggestions on how to improve this piece of legislation, or at least supporting it, but just increasing the threshold amount from 200 to 500,000. But being willing to come into the process, realizing that if they don't, they're just going to be spending, as she puts in her October 26th letter, hundreds and hundreds and hundreds of hours in protests, and they're just in the initial phases of the protest. That's not even going to include how many hundreds of hours they're going to put into court cases and depositions as a result of this. So I ask my colleagues to please support this. This is a very simple amendment. It is supported by the Attorney General as evidenced by the 3 letters I've attached, and I'd ask for the support of all my colleagues for this very important piece of legislation. Thank you, Madam Chair. Madam Speaker.
Thank you very much, Vice Speaker Cruz. On the main motion, I have Senator Ada. I recognize you to speak.
Thank you, Madam Speaker. I rise in support of the amendment. I just really have a simple question, and if the author would yield. I'm just, as a layman, I don't know if when we say legal advisor, that the Attorney General's role then is simply to make sure that the actions that are taken are in compliance with statutes, and does not really in any way judge or evaluate the merits of the procurement that's being made. So, for example, let's say Department of Education decides that it wants to go out and contract for $1 million worth of painting services to paint all the schools pink. I just need the assurance that the legal, that the Attorney General in the role here is not going to say, well, no, that's really an unnecessary service, and so it does not get involved necessarily in the merits of what is being procured, more so than did we put out the announcements, that steps 1 through 10, in fact, get checked off. So I just need.
Will the author yield?
Yes, Madam Speaker. In fact, if the members would look at my original bill said that they shall participate in the process, and it was the Attorney General in her letter dated the 21st of August, who suggested the language legal advisor because she didn't want to participate in the process. She just wanted to provide legal advice, and if you wanted to turn all the schools pink, that's your choice. But whether or not you're going to buy it from a sole source or make it a bid, she would, or the Attorney General would want to have a say that this is something in excess of a certain amount, it has to comply with statute. But the language was the Attorney General's to change my language, which said shall participate, to being legal advisors. So it's clearly understood that they're not going to be in the policy issue, but just in assuring that all the T's are dotted, and T's is crossed and the I's are dotted, and the process goes through, but not as to policy or whether or not they like the pillars at the JFK building.
Senator Ada, are you satisfied?
That's fine, and my that was really the only question that I had, and I think the author has adequately responded to that. Thank you.
Thank you very much, Senator Ada. On the in the main motion, Senator Rector, you're recognized.
Thank you, Madam Speaker. I rise in full support of this bill as amended. You know, sometimes this is penny wise versus pound foolish. It's better to invest the money up front and have the Attorney General involved in the process and get it right the first time than it is to go through this long drawn out court process, which will probably cost 10 times as much. So this is an excellent bill. It's an excellent solution to an ongoing problem, and it's a great example of why we need a full-time legislature. Thank you, Madam Speaker.
I don't know how you got that one in. On the amendment, are there any other speakers? Senator Agun?
Thank you very much, Madam Speaker. I certainly stand in support of this legislation. I think that, Madam Speaker, when you take a look at some of the safeguards that will be incorporated into this particular measure by virtue of involving the Office of the Attorney General during the process for any contractual arrangements that may result in the expenditure of $500,000 or more, are certainly welcome any legal review. The only question I have, Madam Speaker, is as it applies to, I don't know if this provision is only applicable to line agencies, but as it applies to autonomous agencies, would this provision also be applicable to autonomous agencies? Because if the sponsor of the legislation can yield. I ask this question because obviously there was a recent consummation of a contract that perhaps did not reach this particular threshold, but in which we still have questions about the validity of that, and I understand the Office of the Attorney General will be releasing its findings. Now, that's where that particular contract originated, the funding originated from the front office, but it was through the guise of a autonomous agency in which that contract was let out. So my question is, would this particular provision be applicable to autonomous agencies as they proceed with their operational requirement?
Will the author yield?
Yes, Madam Speaker. It would all depend on the relationship that the autonomous agency has with the Attorney General's office. The legal counsel to many of the autonomous agencies do have a special assistant Attorney General relationship and have to clear certain things with the Attorney General. In the situation that you were talking about, you'll note that the legal counsel to the autonomous agency was counseling against doing the very thing that was done, unfortunately, and had he done what I did when I was legal counsel to the governor, employ the assistance of the Attorney General by calling the Attorney General and saying, say no to this immediately, weigh in on this fight, we might not have had this problem. But I think what needs to be done is all the legal counsels to the various agencies need to be able to understand that they can and should recognize the Attorney General's office as an ally, and when they're having problems, to try to get the Attorney General to weigh in and say, we're aware that this thing is happening, and rather than get us involved in a protracted litigation at some future date, we're recommending at this point to do otherwise from what you guys are planning on doing. But the short of it is that enabling legislation have given the autonomous agencies the authority to be able to go off and get their own counsel, and so this does not necessarily include them, unless there is a relationship with the AG's office that would bring them into it. But because of the fact that it may eventually need the governor's signature, and the governor's signature would have to clear through the AG, then they're going to have to recognize that they're going to need to include the Attorney General in the process, and that would be something that they would have to work out.
Can I just maybe just add that if you look in the documents on September 15th letter from the Attorney General on number 6, it says that the government's procurement should be centralized without exceptions for any agency to ensure consistency and to preserve the integrity of the procurement process.
Okay, so there are those additional.
At least that's what she wrote in her letter as part of the testimony submitted.
Okay, thank you very much to Vice Speaker Cruz. Thank you, Madam Speaker, for allowing me to inquire on that issue. I guess the only reason why I do understand that autonomous agencies do have within their enabling legislation the ability to be able to procure and in many cases have their own legal counsel. It's just that the way this reads, if I'm reading it correctly, whenever the Chief Procurement Officer, the Director of Public Works, or the head of any purchasing agency conducts and it continues any solicitation or procurement, and my understanding of any purchasing agency would be all-inclusive of government of Guam entities. So that I guess is where the interpretation comes in terms of whether in fact this would be applicable to autonomous agencies despite the fact that they do have their own legal counsel or the ability to be able to obtain their legal counsel. But I will go with the statements of the sponsor of the legislation and in this particular case the amendment, that based on the enabling legislation and their ability to be able to have their own legal counsel, then that should be sufficient, with the exception of the process having to go to the chief executive, the governor's office, for his or her ultimate signature, then it would be inclusive of the AG's office at that particular stage of the process. So in recognition of that, I'm pleased with the comments and the responses that I've received, and I continue to stand in full support of this measure. Thank you very much, Madam Speaker.
You're welcome, Senator Ogden. On the amendment by the Vice Speaker, are there any other speakers? Senator Respicio, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I rise in full support of not only this amendment, but of the general bill. In that way, it involves the Attorney General in these procurement processes, and I rise in support of this, particularly to stress a point that this Attorney General, by way of this mandate, would be only acting as a legal advisor, and based on what the senator from Manila said earlier, that if the Attorney General is going to begin to participate in a procurement process, to act as if though she's part of policy rather than making sure that the I's are dotted and the T's are crossed, then it might just serve a unintended consequence to have the Attorney General's involvement frustrate any process to procure any government good or service based on the procurement process and laws that we have. So as long as it's clear that she's not, he or she, whoever the Attorney General may be, is not going to be participating in policy-making decisions that are reserved for the other branches, for the governor and for ourselves. In this case, then this thing makes perfect sense. I rise to stress this concern because we know in previous legislatures and with the previous Attorney General, every time the governor tried to do something, you had the Attorney General acting though as if he's part of policy making, and he went above and beyond to prevent things from moving forward, because he started to say that he does not believe that those decisions are in the best interest of the people of Guam, but the decisions were beyond whether or not that process by which was undertaken to procure those services or goods were all legal. It was just based on his own belief that those decisions were not in the best interest of the people of Guam, and it was his own belief as a policy perspective and not legal perspectives. And so I'm very glad that this amendment in this bill is narrowly defined, and it's really important to have the Attorney General be a part of this procurement process to make sure that it's legal and it's above board and nothing else. Thank you, Madam Speaker.
Thank you very much, Senator Respicio. Senator Pangilinan, you're recognized.
Thank you very much, Madam Speaker. Madam Speaker, I certainly rise in support of this amendment, and cognizant of the recommendations made by the Attorney General and the needs of the Attorney General's office when and should this bill pass. We recognize that. I think what's most important at this time is we put in the legal structure and authority for her to get in at the beginning. And as the good author of the legislation said, we will deal with the issue of resources. I think we're going to be dealing with those issues. We did give additional money to the Attorney General's office this year. They have entered into memorandum of understandings with other government of Guam agencies that have federal funds. And so what can happen is that those agencies, which they used to service with existing attorneys, can now fund their own attorneys, their own legal secretaries out of those memorandum of understandings, and that frees up existing attorneys in the office to now be able to do more of the routine work and work like this for the other line agencies of the department. So recognizing, that this will take resources, there are things that this legislature has done, for example, that will be able to free up money that the Attorney General used to have in their budget for attorneys that are now being paid out of the departments and agencies in which federal funds are available for that purpose. We look at EPA for one. We know the Department of Agriculture has now a federal grant that's paid, that has the ability and is paying for an attorney. We know DPW has, up to $6 million available for memorandum of understanding for all the work they're going to do, where all of that work was being serviced by existing staff and existing resources. There are now new resources there that can be devoted to those agencies, which frees up the existing resources to do this kind of work. And certainly the other recommendations with regards to the structure of this facility, the structure of this authority needs to be looked at also. And I did want to then maybe just make a clarifying amendment to this amendment. And there's nothing wrong, when we say legal advisor, I don't think it's going to impede anything. It just means you check in with the AG, you kind of sit down, say, hey, this is where we're going, this is how we looked at it, these are all the processes we're going through, here's all the I's and the T's, and did we miss dotting any of them? And then off they go. The Attorney General does not have to hold their hand for these different autonomous agencies. So I don't think it's going to slow down any process at all. And it shouldn't slow down any process. But I do want to, like I said, make a clarifying amendment that will bring all of that into the Attorney General's office. So on the line, the second line, which is underlined, after the words head of any purchasing agency, I'd just like to add the word any purchasing government agency, instrumentality, or public corporation conducts any solicitation, so that all of these other entities that may not be an agency, that may be a public corporation, but still belongs to the people of Guam and are part of this government of Guam. So any purchasing agency, government instrumentality, public corporation, shall, conducts any solicitation. It would be the normal language we use to describe all government entities.
I think we're going to need to get that in writing.
I think the legal counsel and the clerk will be able to work with that. So instead of purchasing agency, use the normal language we use. Any purchasing government entity, government instrumentality, government public corporation conducts any solicitation.
Okay. So legal counsel, then clerk, would you be able to get that? Okay, so on the amendment to the amendment, Senator Uggan, on the Pangalinan's amendment.
Thank you very much, Madam Speaker. Just a question. It was in line with, consistent with some of the questions that I posed a little earlier, but I'm glad for the clarification, and I certainly stand in support of it. My question, I guess, would be how the language or this particular statement is phrased, Madam Speaker. Whenever the Chief Procurement Officer, the Director of Public Works, or the head of any purchasing agency, I guess the head of any purchasing agency, in my opinion, would be reflective of the Director of Public Works, would be inclusive of the Chief Procurement Officer. So I don't know if that's a slightly repetitious in terms of the phrase, but I certainly stand in support of including the autonomous agencies and the public corporations, because I think that as we move forward over the course of the next several years, especially in light of the era of funding, opportunities that may be opening up or have opened up, but maybe opening up again in terms of expending additional resources, that this particular provision will serve as a major safeguard to ensure and to assure our people that their resources are being properly administered as it applies to procurement. But that was just a question that I had, whether in fact the head of any purchasing government agency / autonomous and public, whether that already would be inclusive of the Chief Procurement Officer and the Director of Public Works. So that was perhaps just a concern that I had. I just had a question.
Again, I meant it to be a clarifying amendment, that you could get into the semantic argument whether that agency includes autonomous agencies, into public corporations, includes GVB, or those kind of institutions, KGTF, and when you use those language, in some instances, some of these agencies have procurement authority vested in their enabling legislation. Some of them are delegated by the Chief Procurement Officer. So by adding that statement, I think it just ensures that we include and incorporate all of those entities and the authorities in those entities.
I hope thank you, Madam Speaker, and thank you, Mr. Speaker. I hope that Mr. Speaker from Barrigada didn't misread my line of question. It was more or less whether the head of any government agencies, autonomous and public corporations, is already inclusive of the Director of Public Works. But if the preference is to just leave the language as is, then by all means, I'm more than willing to yield to that. But I stand in support of this particular amendment to the amendment, Madam Speaker, because I think it really clarifies an issue that our government agencies would be in need of. Thank you.
Is there anyone who would like to speak on the Pangilinan amendment? There being none, are there any objections to the amendment? None, so ordered. On the Vice Speaker's amendment, are there anyone else who would like to speak? Then there are no objection. Oh, Senator Palacios, you're recognized on the Vice Speaker's amendment.
Madam Speaker, I rise in support of this amendment, of course. Also, in my observation, it's just the amendment that was passed was that to include autonomous agencies and those. I was just reading the, I think, fifth line from the bottom after the amendment, and then it says the Attorney General shall, in addition, when he approves contract. And so I understand some of these autonomous agencies have the approving authority, I guess. And so by reading that, doesn't this imply then that this is reserved to the line agencies and to which proposed contracts come before the AG for approval. Otherwise, then, if this is to be left in here, that the Attorney General shall, in addition, when he approves contract, determine not only the correctness. I wonder who, when he approves the contract, who's approving the Attorney General or the contracting agency? I just want to clarify that so that we don't.
Would you like the author to respond? Is the author here? Okay. Sorry, I couldn't see you back there. Vice Speaker?
Yes, the language is as is currently in the statute for that line. And I think in the contract that some of us were concerned about, you'll note that the governor's signature was also necessary in there, which necessitated the Attorney General signing off on it. So I have yet to figure out when the governor's signature is required, but it just seems to me in the ones that we've been seeing, the governor's signature is on most of those. Whether or not he's, but before his signature can be affixed, the Attorney General has to approve the contract before his signature can be affixed to it. So the office will always be involved in that process. Thank you.
Senator Palacios? Yep. Are you done? Okay. So then, are there any objections then to the Vice Speaker's amendment? No objections? So ordered. On the main motion then to send it down to third reading, the Vice Speaker, do you want to close or?
Thank you. I just want to thank my colleagues for their support and also assure them that this is just the first step. On Tuesday, I am meeting with the Attorney General and representatives from GSA, and if I know we're going to be in session, but this issue is so important to me to try to get this procurement. When Chairman Palacios conducted the hearing with the Attorney General, I asked her the question about how do we improve the procurement statute, and I was suggesting that maybe we should adopt wholesale the federal procurement law, since all of these contracts are going to be coming, and I can see the good senator from Barrigada shaking his head, because there are many problems with the federal procurement statute. And the model procurement statute that we based ours on, we took some of it and then we left a whole bunch of it out. And so I wasn't going to let grass grow between my toes in this issue, and I've been trying to find a time where she was free to come back to the office, and she and I are going to follow up on the the hearing that was conducted by Chairman Palacios, and to expand on it, because I want an answer. How do we improve the procurement statute so that we take care of all of these issues? I mean, what do we need to add? What do we need to take out? What processes need to be put in it? And I'm still moving on that, Madam Speaker, and I will continue to keep all of you advised and apprised of those meetings and also of the progress or lack of, because I want this addressed. We're spending too much time in procurement protests, and our children and our most vulnerable are the ones that are suffering. And this has got to stop. And so I thank you for at least this first very, very small step. But as a great philosopher says, you have to take the first step in this trek of 1,000 miles. So I appreciate the help in at least this first step, which the Attorney General's office does support, and I will continue to work with the Attorney General's office to make the big holistic change that is necessary in the procurement statute so that we can try to put an end to most of these protests. But I thank you very much for giving 220 the opportunity to be heard and to be addressed today, and I ask that it be moved down to the voting file.
On the motion to place 227 in the voting file, no objections to order. I'm so sorry, you're right. It's because I pulled up the next bill. It's 220, so no objections to that, so ordered. We're now then on Bill 227, and the author is Senator Palacios.
Thank you, Madam Speaker. Madam Speaker, I move that Bill 227-30 be placed on the reading file and for purpose of discussion. And if I may just give an overview, please.
Proceed.
Madam Speaker, there was a time in the past, and as recent as about a year ago, parole officers were being compensated hazardous pay for their work in supervising and counseling parolees. And somehow, about 12 months ago, someone from the parole division, I understand, at this one employee went down to because of transfer, went down to the Department of Administration and advised them that they are not entitled because they were not guarding prisoners. And so, sad to say that DOA adopted, I think, that thinking. And so, 8 months ago, they suspended that. And in my research, Madam Speaker, the probation officers, for example, and the alternative sentencing officers of the court are eligible for hazardous pay. And what do? Of course, they supervise and counsel probationers. Actually, parole officers are the counterparts of probation officers. However, of course, the parole officers are not entitled for doing like functions. The correction and parole officers also who were assigned to a multi-agency task force, as we are seeing nowadays, and those who were assigned to the executive security and who serve alongside police officers, judiciary marshal, and customs and quarantine, perform the same duties, but are not eligible for hazardous pay because according to the statute and the interpretation of DOA is that they are not quote-unquote guarding prisoners. I guess when the hazardous pay for the Department of Correction employees was implemented, it was a long time ago where they functioned only within the correction institution. But with the continued maturity of the law enforcement profession, now they have the multi-agency task force. I guess they augment here and there so that you create, I guess, a more uniform, I guess, law enforcement community and able to augment the force of the other in times of needs. So it is in this context that this bill came about, is to provide, to correct what appears to be inequity. And I give an example, a clear example of a multi-agency task force right now. There's a multi-agency crime task force that that's a combination of the U.S. Marshal, for example, sometimes the ATF of the FBI, the Superior Court of Guam, Customs and Quarantine police officers, and then maybe a member from the Department of Correction, a parole officer, and like that. Now, all the other members of that multi-agency task force from all the other agencies, by statute, are entitled to hazardous pay. Performing side by side, a correctional officer is not, because according to the statute, of course, they were not guarding prisoners. And it is my contention, Madam Speaker, that the hazardous condition attributed, for example, to a prisoner while incarcerated is not extinguished when the same prisoner is released on parole and subsequently supervised and counseled by a parole officer. And again, you know, it has to do with, furthermore, of course, the hazardous condition associated with the mission of multi-agency task force are not diminished against a correctional officer just because a correctional officer is not entitled to hazardous pay. It has nothing to do, I guess, with title or status. Actually, hazardous pay relates to the condition. And this is more or less a remedial bill to remedy what is, at this point, is inequity. And I was approached by these officers. If I can at least present this for consideration by this body, otherwise, as we speak, they are still in this multi-agency task force. The executive security, one individual that assigned there to augment that, and at the same time, you know, to, I guess, to diversify the capability of certain individuals, do not receive hazardous pay. The police officers assigned to the government house, executive security, they are receiving hazardous pay. And so these are the situations, and again, what this bill proposes to do is just to provide, to remedy the inequity and I guess correct this unfairness so that it prevents a potential morale problem at this point. And I ask my colleagues to consider this, and if they can improve on it, I appreciate that. Again, the others that are working next side by side with these officers are getting hazardous pay by their department and by the statute that establishes their positions. I guess the statute for the correction needs to be updated and to recognize that it is the condition to which the hazardous pay is attributed and not to the classification of the employee. Thank you, Madam Speaker.
Welcomes Senator Palacios. On the motion then to place Senator Taitigui.
Thank you, Madam Speaker. I stand in full support of this bill. I believe it's been an injustice in the criminal department, or the officers, the police officers, who do not receive this hazardous pay. And one of the biggest concerns that I have is that whenever someone who has to carry a firearm, that's got to tell you already there's a hazard right there to be required to carry one. And these parole officers do. At the same time, I was concerned about the funding, because it's very important if we're going to pass legislation that accompanying that would be funding as well. And according to J.B. Palacios, the director of Department of Corrections, that it has been funded, and this will affect 14 officers, and the funding for them has already been, the amount of money is funded is already there. It's just requiring the authorization to do this. So that being said, and also, by the way, my office is on the 5th floor, right next to the parole office, and seeing individuals come in and out of that floor, and seeing the situation they're put in when individuals come up for parole hearings and as such. For me, it gets kind of scary, but they are definitely, as I see it, watching them every Thursday, I believe, of the month, that they come up for these hearings, that there is obviously a danger involved, and they should not be exempt from this hazardous pay. And I ask my colleagues too to also support this, and ask that I be co-sponsor on the bill. Thank you, Madam Chair. Speaker.
On that motion to include Senator Taitigui as one of the co-sponsors without any objections, so ordered. Senator Rector, you're recognized on the motion, the main motion.
Thank you, Madam Speaker. I too rise in support of this bill. It's about time. You know, when we talk about parole officers, first off, I never agreed with the assessment by DOA. A parole officer is guarding a prisoner. It's just a prisoner that's not in prison at the time. It's, or as they say sometimes, I believe the appropriate term would be convict. It's just a convict that's been released that a parole officer needs to supervise. I do have a simple amendment to this. And if we look on line 17, it says the differential shall be applicable only during time of exposure. And I would propose that we amend that to say the differential shall be applicable during all duty hours. And to make the same change on the next page, page 4, line 3, the differential shall be applicable during all duty hours. And I'd like to speak on that amendment, if I might.
Yes, you can continue. Yes,
Okay,
you can
thank
continue.
you. Sorry, I didn't hear you there. Yeah, one of these problems is, this is another problem that needs to be corrected. The differential shall be applicable only during times of exposure. The literal definition of that would be if you're a parole officer and you're sitting in your office and a parolee comes in, it's like as soon as they walk through the door, boom, you're on the clock, and then as soon as they go out, boom, you're off the clock. Well, first off, that's a record-keeping nightmare, which would lead to it would end up costing us more to keep track of all those records than it would cost us to pay him the whole time. So I don't think that's going to be an issue when it comes to funding. But it also comes to just common sense and justice. If you're a parole officer, every hour you're on duty, you are in hazardous duty status. As a matter of fact, every hour you're not on duty, you're in hazardous duty status. I mean, you know these officers all have to carry a gun with them at all times, not just when they're on duty, because they need to protect themselves. Their job is to supervise convicts, which is a dangerous profession. And if they get up from their desk and they walk through the hall, but they're still convicts in the office. They're still in a hazardous duty status. So I ask my colleagues to support this amendment and make this right at all times. Thank you, Madam Speaker.
Thank you very much, Senator Rector. On the amendment, Vice Speaker Cruz.
Thank you, Madam Speaker. I rise in support of the bill and the amendment. I don't think we need to look very far. Just the last month and a half on CNN with the problems that we've been having with parolees. I mean, if it weren't for that shooting today in Fort Hood, we'd still be covering the Ohio parolee situation where they've now found 11 bodies in the backyard of a parolee. The Garrido situation in California shows that parole officers really should be provided with as much protection as they can so they can properly supervise these individuals that, because their time has come to be released in the community, need to be properly supervised. And I really do think that their inclusion in receiving hazardous pay is well worth it and is demanded because of the work that they're doing. And hopefully we'll never have the situation that we've been watching on CNN happen here, but we need our parole officers to be willing to go out there and do what needs to be done to ask the difficult questions and do whatever needs to be done to make sure that our children and our families are safe. So I support this bill and this amendment. Thank you.
Thank you very much, Mr. Vice Speaker. Are there any others who would like to speak on the amendment? Senator Espaudon.
Madam Speaker, thank you. The amendment is to change the words, the sentence that says the differential shall be applicable only during time of exposure to now read the differential shall be applicable during all duty hours. It seems to me that those words then basically gives a 10% increase to all parole officers. And I'm just wondering, is that the intent behind this? I mean, which is just with the justification of the arguments that the proffer of the amendment just made, that because they are in dangerous situations that they should be given that differential pay, or excuse me, that elevated pay during all their duty hours. My concern is, again, are we raising their pay basically across the board without benefit of the Hay study and anything else? And that's the question I suppose I'm asking.
Would the mover of the amendment, are you willing to respond to the question?
Yes, certainly. Thank you very much. Look, hazardous pay is when you have hazardous duty, and at every hour, these folks are required to carry a gun. At all times, you're required to carry a gun.
Madam Speaker.
Please state your point of information.
I don't know that there's any law that requires them to carry a gun. And if the gentleman is stating that, I'd like to just request that he cite that statute.
I don't know that statute. I thought so. Because I have talked to these folks, and I thought that they were required to carry a gun. So I might stand corrected. But one way or another, they deal with convicts at all times. It is a hazardous duty. All the time. Even when they're not on duty, it's hazardous. I mean, if you send somebody back to prison, it's hazardous. So I think they're on hazardous duty at all times. Thank you.
So I would imagine, Madam Speaker, that the answer to that is yes, we are increasing everybody's pay, or these people's pay, these officers' pay by 10% through this legislation. And as such, I'm not sure I can agree with it using this methodology. Again, I don't think the public hearing was held to address that situation.
and I don't think there was any public input. I don't believe that there was any input from DOA or any other government agencies to be able to say whether we could do this at this point in time and whatnot. So with that explanation, I would abstain against the amendment. Thank you.
Thank you very much. Please state your point of information, Senator Palacios.
Thank you, Madam Speaker. Madam Speaker, with respect to the Guam Police Department, the application of the hazardous pay is for on-duty hours, which is essentially the entire 8 hours. But there are some statute of hazardous provisions for other agencies like the court that would say the language is during time of exposure. So it depends on the agency to which, in which this hazardous pay is applicable. It would not be, of course, improper or out of the ordinary if for all the duty hours would be applicable, would apply with respect to the correction. But at this point, actually, the bill is during the time of exposure, which is actually the ordinary language for that, including the courts, and I understand the airport police and so forth. But I'm not objecting to the amendment. I'm just providing an information.
Thank you very much for that information. Senator Balash, you are recognized on the amendment.
Thank you, Madam Speaker. Madam Speaker, I'm going to have to agree with the good senator from Tamuning here with regard to the concerns that he has here, and I recognize that the individuals. I come from law enforcement, but yesterday I remember recalling yesterday there was a whole argument, and there was a whole discussion with regards to the pay that people get for the work that they do. And it's not to take anything away from the officers, because they do the work. And maybe someday down the road we're going to have to be able to address whether or not they're being properly compensated, and that's why we're having the Hayes study that's being conducted. But I'm also looking and based on just on the bill, I recognize where the lines have been. The new language is being inserted, which is the proffer of this legislation is to include a parole officer, and include as a result of when this parole officer is eligible to receive this hazardous pay. It's a start. It's a start. I caution that if we're going to start to do this and we're going to go down this slippery slope of looking at, again, I have to go with concern brought up by Senator Espaldon in further input that's going to be needed. There, and as stated by the author of the legislation, that different statutes dictate the kind of pay that people get, when they perform hazardous duties. There's hazardous duty for linesmen at GPA. There's hazardous duty for linesmen at waterworks. We're going to have to address hazardous pay duty pay that we should probably give to our individuals who work in the judiciary who do process serving. But I don't think it's time to do that. This legislation here proposes to start to address it. So I can appreciate and I understand where the mover of the amendment is at in wanting to go this. I don't disagree with him, but I think there's a process that exists too, so that we can include the discussions for everybody else. Thank you, ma'am.
On the amendment, Senator Pangilinan, you recognize.
Thank you very much, Madam Speaker. Madam Speaker, the bill was introduced to correct an inequity and bring some parity between these police officers who deal with prisoners who have been released from prison because they're no longer a threat to society, they're no longer dangerous to society. I mean, that's why they're released. They're not incarcerated. They've determined in the process of their evaluation for the time they've served that it is safe to release them into society. and therefore they are released under certain conditions because we still want to make sure and keep track of them. And so that's the police officers, parole officers' position and duty and responsibility is to monitor and track these convicts, as the good senator had mentioned, who have been deemed ready to be released and able to be released into our community and not pose an immediate danger and threat to the safety of the community. So that is, the status that these people have achieved in order to be released and now be under the supervision of the parole officers. And we wanted to say that, okay, so when you're in contact with these men in their duty within the correctional system, then because technically they're still prisoners, you should receive hazardous duty. To bring them to parity with their counterparts in the correction system of the guards at the Department of Corrections, which is that a corrections officer, when he's guarding a prisoner, shall receive, that's the basis, when he's guarding a prisoner, when he's in contact, when he's in direct exposure to that prisoner, then he gets hazardous pay at the rate of 10%. With the amendment, now, where we were trying to bring parity, now we're leaping over the corrections officers, where now the corrections officers are not eligible for hazardous pay for all duty hours. They're only eligible for hazardous pay under certain conditions. Now we're saying that the parole officers who we were trying to make equal to these corrections officers are now above them. So that is, that rationale of trying to bring parity has just been eclipsed.
Point of information, Madam Speaker. My amendment corrects both of them to include that. That's why there was 2 corrections on it.
Page 3, lines 17, and page 4, line 3. Yes.
Correct. Thank you. So it would have parity. It applies to both correction officers inside the prison and correction officers on parole as well. Thank you.
You may continue, Senator Pangilinan.
Oh, I see. So we're now increasing the payroll of the Department of Corrections by, I guess, $1.3 million. That's the net effect. If I remember correctly, the total payroll is maybe somewhere in the neighborhood of 13 mil. I may be mistaken on that. 13, 14 million. So now we're going to increase the payroll cost in this budget with no money to pay for it by $1.3 million. And I guess, trying to put that in place, make that promise without the ability to deliver on that promise, I think is something that I'm not ready to support. Again, the law was such, it's the same with the police officers. So now the police officers who are eligible for hazardous pay, law enforcement officers, have now just been eclipsed because not every police officer also is entitled to hazardous pay. That hazardous pay for police officers is such that the police chief has to develop a table of organization and identify those positions that will be eligible. So now we've given a 10% increase to law enforcement or corrections, and we're leaving the police officers behind. Again, it's this idea that, every time we see an opportunity to advance something, that it doesn't matter, it doesn't become uniform as we're trying to achieve here in terms of bringing parity, and we're just going to be so disconnected with this thing that while we're trying to fix something there, we're creating a problem here. So if we do this in this fashion and in this manner, we're going to now leave the police officers behind, because this basically says everybody at DOC and within the DOC system gets a 10% pay raise, and the police officers are left behind again, and so forth. The fire officers are left behind. And again, we've been trying to bring this whole system back. We've been trying to bring this disjointed approach to the uniform pay scale, to equity and parity, to the job position and the job duties and the job conditions reflect the pay, and we're making those attempts at this time, and I'm going to continue towards achieving that in that fashion. Thank you.
Thank you very much, Senator Pangilinan. Senator Dragon.
Thank you very much, Mr. Speaker. I think that I too stand expressing perhaps my reservation in terms of even supporting the amendment to the legislative measure, primarily because of what was just stated a little earlier by the previous speaker. As it applies to law enforcement, which is inclusive of correction officers and parole officers, they were provided a 40% pay adjustment, 10% incrementally. This is the second fiscal year. And I think that as we move forward, obviously they're going to realize that the other 10% in fiscal year 2010 or 11, and then the subsequent fiscal year to get them up to that level. Now, so it's not necessarily a concern, at least from my perspective, in terms of looking at whether these law enforcement officers deserve the pay, because this legislative body, in its infinite wisdom, in the 29th Guam Legislature said, yes, our law enforcement officers deserve an incremental adjustment over a 4-year time frame up to 40% so that in fact they can be properly compensated. Now, in terms of looking at this, there was one particular statement that was made that I'm going to have to differ with, and that is that it creates a horrendous nightmare in terms of accountability. I know of a particular law enforcement entity that the responsibility falls on the shoulder of two individuals. One is the law enforcement official who is tasked with identifying exactly when they were exposed to the hazardous conditions or hazardous environment, and then the other one would be consolidating and collaborating with their supervisor so that at the end of the day or at the end of the week, everything can be properly justified. I don't think there's been any question raised over the course of the last year that I'm aware of, over the course of the last 2 years, as to whether that process has worked. And that's in reference to the applicability of hazardous pay during times of exposure while he or she is on duty. So I just wanted to share that perspective, knowing full well and having been instructed of how the process works in that particular entity, that it can work. It has worked and is still working to this very day. So I certainly stand expressing my reservation in regards to the amendment. Thank you very much, Mr. Speaker.
Anybody else wish to be heard? Senator Rector, do you wish to close on your amendment?
Certainly. Thank you, Mr. Speaker. Yeah, we've been here before, and I'm sure we're going to be here again. To say that just because somebody has been paroled, all of a sudden society has deemed them safe, I would have to differ with that. As you yourself pointed out earlier, there's cases all across the nation. Recently, a case that talks about a horrific behavior of a parolee that was, quote unquote, deemed safe to be released, and they found all sorts of bodies in his house. You know, if they were deemed safe to be back in society, they wouldn't be on parole. Parole is a trial period where we transition somebody from full incarceration to full citizenship. And it is a hazardous. There's no crystal ball that says, oh, this parolee's like going to be great. They came out fine and they're going to go back into society. Or this one's a dangerous person. Or is that what we're going to, is that how we're going to conclude, like when they're in hazardous duty? Or is there somebody that's going to wave a wand when this happens?
Mr. Speaker, point of information. The point I was making on that is that I'm not saying that you're going to decide which parolee and exposure to which parolee is going to be eligible for hazardous pay. I'm saying all exposure to parolees will be paid hazardous pay.
Thank you.
Thank you. Yeah, it's a dangerous job. It's a dangerous job all the time, in my opinion. And I would think that anybody that knows a parole officer that talked to him would know it's a dangerous job at all times. And being a correction officer is a dangerous and difficult job. So, do I think they deserve 10% at all times they're on duty? Yes, without a doubt. And I would like my colleagues to support this. You know, for some reason, we always seem to find reasons not to take care of the men and women that take care of us. And I think we ought to start looking for reasons to take care of them. And I think this is a step forward. Thank you.
Thank you very much. On the Rector amendment, does everybody understand the amendment? We're going to be taking a vote on the amendment. Can I have everybody's attention? All those in favor of the Rector amendment, please indicate by raising their hand. Amendment fails. On the main bill, Senator, anybody else wish to be heard on the main bill? On the main Palacios bill, does anybody else wish to speak? Senator Pangilinan.
Thank you very much, Mr. Speaker. Mr. Speaker, I stand in support of the bill. As indicated earlier, an interpretation was made by the Department of Administration based upon the statute, based upon the law that is in place. They didn't make that interpretation, or they didn't change the policy because they didn't like parole officers, or they didn't think parole officers didn't deserve it. The department made that interpretation that parole officers were not eligible for hazardous pay because the law that governs their position and their classification did not put them in the condition that would allow them to earn that hazardous pay. The law was very clear in terms of guarding prisoners, and their interpretation was that these parole officers are not guarding prisoners because they are supervising them. They are not physically with the prisoners, keeping them confined in a certain environment pursuant to a sentence that was given to them. That these prisoners are of a different status and as such are not prisoners. So the people at the Department of Administration weren't doing this because they want to deny them 10% or they don't think that these people's jobs are dangerous. They're just saying that the way that the law was written was such that these parole officers didn't fit into that statute. And so the bill here would recognize that yes, working and being exposed to parolees is dangerous, that it presents a hazard to that employee under the same terms and guidance given for corrections officers of guarding these employees when you're directly exposed to them. And so the way that this bill has sought to resolve that problem is that when these parole officers are dealing with these prisoners who have been released from prison and are now transitioning into society, that would be considered hazardous pursuant to the statute that governs the corrections officers and their status and exposure to those hazardous conditions. So it is necessary for statute to be passed given the interpretation that has been taken by the Department of Administration. Now, and the reason why statute is necessary is because there has been differing interpretations of that statute. In the past, under a different regime, the Department of Administration saw enough leeway to say, we will pay hazardous pay to these parole officers under these conditions. And those parole officers were paid. With a change in the regime at the Department of Administration, they took a look at the statute, they made a new interpretation, and then they removed the authority to pay that, and therefore the Department of Corrections cannot get the Department of Administration to process the payment and agree to pay these police officers under the existing statute. So that's why legislative intervention is needed. And that's why I support this, because I do recognize that while these individuals, these parole officers, are dealing directly with the prisoners, just as the corrections officers are directly supervising and guarding those prisoners, then it brings parity to that situation there. There's no debate on whether one's more dangerous or the other. It's the situation, the condition is dangerous. It is the exposure to the individual, to the criminal, to the convict, to the prisoner that presents that hazardous condition. And when you're exposed to that condition, you should be compensated for it. Just as the corrections officer who is at the PDN building, who's removed from the DOC compound, and there's no prisoners being supervised or guarded in that facility, they're not paid hazardous pay because they're not in direct contact with those prisoners. And that would be the same way that parole officers would be treated under this statute. So it brings parity, and that's really what we were trying to, or the good author was trying to achieve, that when the individual is exposed to that condition, which has been determined to be hazardous, which is exposure and direct supervision over direct exposure and direct supervision and contact with these prisoners, then that situation deserves that extra 10% for hazardous pay. So I stand in support of this bill. Thank you very much.
Any other senators wish to be heard on the main bill? If not, the sponsor may close.
Thank you, Mr. Speaker. Mr. Speaker, I appreciate, of course, the remarks and comments and support of my colleagues. If in my earlier presentation somehow I seemed to insinuate that DOA just didn't want, no, I believe that DOA was just following the statute as it is written, and it is a very strict, narrow statute, and that is why it remains with this body then to remedy that inequity. And I hope that I'm beginning to feel confident that this body will pass this bill and correct that inequity. Thank you, Mr. Speaker. And I move that it be placed in third reading file for voting.
Any objection to it being placed in voting file? Hearing none. Senator Especia, do I understand you have something for the Speaker?
Thank you very much, Mr. Speaker. Madam Speaker, who is also acting governor, has the following three bills on the agenda: Bill 229, Bill 231, Bill 233. All of these bills have been passed out, copies have been made, and she's requesting that we push these to the side and proceed with Bill 236, and then we'll pick up where she's left off on that motion.
Thank you very much, Senator Especia. Senator Rector, Bill 236.
Thank you, Mr. Speaker. Bill 236 is a really simple bill. It basically restores the proper night differential pay to all public employees, and I move that we move it to the third reading file.
Any objection? Hearing none.
Thank you. And if I can speak on the bill? Or I don't need to anymore, it's already moved.
Point of order, yeah, it's already been passed to the third reading file, right?
Well,
He didn't request to speak on it, so.
I'm not going to try to do. No, I'm not going to allow them. I know. I would.
Fine with me, either way.
No. It's Senator Especia. Rector, please.
Thank you. Then I would like to speak on it. Thank you, sir. Yeah, this was changed a few years back, basically as an opportunity to balance the budget on the backs of some of the hardworking public employees. And the way it currently reads, that they only get night differential pay if they work a minimum of more than 4 consecutive hours during the night period. And what we found over the years is people would work them 3 hours, work them 3.5 hours, have them come in like 2 hours early and stay an hour late, or 2 hours late. And they could literally work them a long period of time without being in night differential pay. And that caused undue stress to many workers. And there's a reason for night differential pay being up. You know, this is the time when workers spend time with their families. You know, we talk about family values. Family values is when dad can have dinner with the kids, help them with their homework. Mom can tuck her little darlings into bed, read them nighttime stories. When they're robbed of this family time, the least we can do is give them the 10% night differential, even if it's only for 4 hours, or 3 hours, or 2 hours. I ask my colleagues to support this bill. Thank you, Mr. Speaker.
Are there any senators who wish to be heard on Bill 236? Senator Ogden.
Thank you, Mr. Speaker. And just to provide a little bit of history, I think it's wonderful that the finances, and I'm not going to say that things have turned around, but the finances are stabilized to some extent, because I remember back when this particular provision was enacted, and it was, yes, it was a budgetary consideration, and it was a difficult one that the members of the legislature at that time had to make, but it certainly moved in the direction of recognizing the limited resources that we had at that point in time. It was not to try to break the backs of the family members, but it was in direct recognition of budgetary restrictions at that time. And I think, and I certainly would never hope that members of this legislative body would have to go through some similar financial challenges that a few of us have had to endure in terms of making some very difficult decisions. But aside from that, I stand in full support of the restoration of the night differential hours as provided for in Bill number 236 as 30. And Mr. Speaker, I encourage our colleagues to also do likewise. Thank you.
Any other senators wish to be heard on the bill? Senator Tello Taidegui.
Thank you, Mr. Chair. I stand in support of this bill that's put forth through us. It's basically reflecting what the federal government has in statute with regards to night shift differential pay. But I would like to make an amendment to this, and since we are following the same law that federal government reflects, and taking out the part of having 4 hours minimum in order to receive night differential pay, because the federal government as well does not have that in their law. But we do have that scenario where if you're reflecting it, then I think it's in entirety because of the way their study has made that 6 p.m. to 6 a.m. is what the federal law has. And of course, you know, I think if it's good enough for them, it's good enough for us. So I think that 7 o'clock is actually putting it to a point where it's going to cost us a lot more money. It might not seem that way, but it would. So I would like to just make an amendment to this and bring it to what the same standards as the federal government is, which is to take it from on page 2, line 6, take out 7 a.m. and put back the 6 a.m. as reflected in the federal government. That's my amendment.
Thank you. On the Taidegui amendment, any senators wish to be heard on the Taidegui amendment? Senator Director.
Thank you, Mr. Chair. Or Mr. Speaker, excuse me.
RERS.
It's yeah, I appreciate the comparison to the federal workers and wanting the public employees on Guam to receive exactly the same benefits and working conditions as federal workers, which would mean they would get a 25% tax-free COLA on top of their salary. So maybe we should make that amendment so that we have that kind of parity. Or better yet, let's make it so they're attached to the exact same pay scale and get the 25% COLA on top of it, and get the same retirement, and get the same health plan. that would be fantastic, and I will vote for that 1,000% of the time. And then we can knock that extra hour off where the hardworking men and women of the government of Guam get to fix breakfast for their kids, or take their kids to the school, or take it to the school bus from the hours to 6 to 7. These are the critical hours with our families that these folks lose. I mean, 6 to 7 is when children are going to school. It's when you're standing at the school bus for little Johnny that's 3 years old, or I guess they don't go to school at 3, but they go to school at 6, when it's almost dark out, and they get to supervise them, or fixing them breakfast, or packing their lunch. I stand opposed to this amendment. Thank you, Mr. Speaker.
Thank you. Senator Argan, any others wish to be heard on the Taitigui amendment?
Thank you, Mr. Speaker. I think the explanation that was provided by the mover of the amendment to the legislative measure, I think is sufficient in terms of looking at exactly what this would provide, night differential pay. It's my understanding that by about 6 or 6:35 a.m., the sun is bright out, and apparently daylight has already assumed its responsibility during the course of that particular day. So I will stand in support of the proposed amendment. Thank you, Mr. Speaker.
Any other senators wish to speak on the Taitigui amendment? On the Taitigui amendment, there's an objection, so all those in favor of the Taitigui amendment, please signify by raising your hand. We got the 8. Passes. On the Rector bill, Senator Taitigui, you have another amendment?
No, Mr. Speaker. I just like a question, if the author would like to yield to a question that I have on this bill, on his bill.
And the question?
Okay, is he okay with it?
Well, let's hear the question, and then he may not want to answer it.
When it's putting this bill together, my question is, and I'm very concerned because, you know, we can't be sitting here as a legislators putting things through without being able to fund it. That was one of the biggest problems, even as a young girl, when I used to watch the legislature put through laws that, well, I hope to goodness that they have the money to pay for this. And as I looked, and as being a senator and looking at our deficit and seeing how far we are in the hole there, and it continues to rise, you know, every year, then I would like to ask the author of this bill, has he had a chance to have a financial impact study with regards to just how much more additional pay is this going to cost the government of Guam?
Does the author wish to yield? Thank you. The author does not wish to yield to the question. Thank you.
Then I would like to proffer an amendment to this bill. And basically the amendment is to, before this legislation passes, or to have it if you give me 1 minute, Mr. Speaker, I'll have that amendment ready for you then. Okay.
Thank you very much, Ms. Speaker. Ms. Speaker, in light of some new developments relative to the bills that are in the second reading and even third reading files, I'm going to move that we recess until Monday. The Committee on Rules will spend some time over the weekend going over all the bills and make sure that all the items contained in the committee reports on all those bills that were placed on the agenda are sufficient. But what time? Yeah, what bill, what number? But actually, we probably have to start with me giving a report on the bills that require resolution. Yeah, we can always go in the committee on Monday. But I'll do an advisory bill. So my motion is to recess until Monday at 9, but to advise the body that until such time the Committee on Rules has an opportunity to make its report regarding the matter I just presented, we are going to follow by going into the Committee of the Whole, but I'll make that motion on Monday. But my motion is to recess till Monday at 9 a.m.
Thank you very much, Majority Leader. I guess we're recessed until 9 a.m. on Monday morning.